Thank you. So, as we know, international investment law is a system which is in search for its identity. But in the meantime, there is a need, precisely because there is a lack of identity, as I will get back to later, there is a need for comparative reasoning. And this is actually a tool which is very often used by arbitral tribunals in relation to the primary sources. So that's used in the interpretation of international investment agreements, IIAs, as I will call them today. It is used in the determination of customary international law, obviously, and also in the identification of the general principles of law recognized by civilized nations. So today, I will mainly focus on the use of comparative reasoning in the context of the interpretation of IIAs. So as we will see, comparative reasoning is a multifaceted process, all its facets raising specific issues, but each from their own perspective begs, I think, two main intertwined questions. So from first a legal point of view, how does comparative reasoning fit into the theory of sources and with the canons of treaty interpretation? From a legitimacy point of view, what to think of the strength of a comparative reasoning in terms of argumentative value? So those two questions are the core of my presentation, but to pave the way for this discussion, I will first briefly explain the reasons why comparative reasoning is needed in investor-state arbitration, and second, what the materials, so to speak, of comparative reasoning are. So first, the grounds for comparative reasoning in investor-state arbitration. So I think those grounds are mainly twofold. First, legal indeterminacy, and second, systemic hybridity. So more specifically, as regards systemic hybridity, I will make a distinction between two dimensions of hybridity: ratione personae hybridity and ratione materiae hybridity, knowing that those two dimensions interact and amplify, I think, the hybridity of the regime. So let's start with ratione materiae hybridity. So this pertains to the legal features and components of the regime. And actually, ratione materiae hybridity has characterized international investment law for a very long time. And it has characterized it actually since its very genesis in the late 19th century. At that time already, international investment law was connected to public international law. For instance, the minimum standard of treatment is a good illustration of this. But it was also connected, for instance, to a transnational legal order. Think of the importance of the lex mercatoria in this field. Nowadays, obviously, the treatification of the field has more firmly attached international investment law to public international law. It remains that there is still ratione materiae hybridity, especially as regards the features of investor-state arbitration. Moving on to ratione personae hybridity. Here, this relates to the features of the epistemic community in this field, mainly arbitrators, consuls, and academics. Among many features, the diverse legal background and the diverse legal culture of all those stakeholders are key as they influence the comparative reasoning they conduct, in particular in dispute settlement. So in this regard, I think we should be cautious not to oversimplify the epistemic landscape and legal practice in the field. Why? Because a number of those stakeholders, arbitrators for instance, have themselves a diverse background and notably rooted in different legal orders or different legal disciplines. Also, one should take seriously into account that the capacity in which they act in the system as an arbitrator, as a counsel, also has an impact on the way they rely on their own substantive background. So in other words, I think it's important to realize that comparative reasoning is not only a matter of knowledge, that's also a matter of interest and a matter of values that the stakeholders want to promote, to defend. So all this leads those stakeholders to focus on different specific features of the system or to construe the very same feature differently. So as an example, take state consent to arbitration. Depending on the background, arbitrators conceive of it differently, and this has serious practical consequences, for instance, as regards the interpretation of preconditions to arbitration or the interpretation of the most favored nation clause as regards its connection to dispute settlement mechanisms. More generally, those diverse backgrounds, interests, and value generate diverging, conflicting epistemic forces which reinforce the ratione materiae hybridity of the regime. And this is where legal indeterminacy, which has for a very, very long time characterized treaty practice, come into play. Because to deal with this indeterminacy, notably when the rules of interpretation fail to deliver a meaning, those stakeholders often rely on general paradigms or specific rules that they consider being relevant for functional or for strategic reasons. So which leads me to briefly introduce the materials of comparative reasoning in investor-state arbitration. So I will be brief on this, and I will make a distinction between two main types of comparative reasonings: systemic comparative reasoning and specific comparative reasoning. So starting with systemic comparative reasoning, which, as we'll see, has an impact on specific comparative reasoning, this consists in the comparison of international investment law with legal systems and paradigms. Here again, exploring these landscapes requires to avoid oversimplifying things, as it is more complex than it appears at first glimpse. So of course we have main groups. So for first main distinction can be made between domestic law and international law. But within this within these categories, we find subcategories. So domestic law, we can see, looking at arbitral practice, that there is the influence of public law or tort law. We can see that there is the influence of civil law and common law. As regard international law, we have subcategories also. Commercial, private, international law. They are all paradigms which play a role in arbitral practice. But when one looks even more closely to the practice, the landscape displays a greater diversity. So let's take just international law as an example. So within that box, we find the influence of general public international law, the influence of international human rights law, the influence of WTO law. So again, a much greater diversity than what the traditional narrative on the field tell us. So this systemic comparative reasoning has serious practical consequences. I've just mentioned state consent to arbitration, so we can discuss other examples afterwards. Moving on to specific comparative reasoning. So here I mean the reliance on specific legal instruments, specific rules, specific principles. So here also we can make a distinction between those instruments, principles, and rules which belong to public international law or to domestic law. As regards public international law, tribunals often rely in their reasoning on past arbitral awards, less frequently on past judicial decisions of other international courts and tribunals, and also they rely on other international investment agreements. As regards domestic law, they rely on specific rules or principles. Here we can think, for instance, of the fair and equitable treatment and the role that it plays as regards the concept of legitimate expectations, for example. So now that I have briefly introduced the reasons why legal reasoning is used, the materials of comparative legal reasoning, let's now focus on the issues that comparative reasoning raises in the field. Well, almost by definition, any comparative reasoning raises methodological issues. This is true in investor-state arbitration as it is true in any judicial forum. So irrespective of the nuances which are attached to systemic comparative reasoning and to specific comparative reasoning, those methodological issues pertain to the determination of the terms of the comparison, to their similitude or the lack of similitude, and to the comparison stricto sensu. So I would like to approach those issues from a legality and a legitimacy standpoint. So first, the legal perspective. So here I will discuss comparative reasoning in relation to the theory of sources and the canons of treaty interpretation. And doing so, I will focus in particular on comparative reasoning when it relies on judicial decisions and on domestic laws. So, as I've just said, if you look at arbitral practice, arbitral tribunals mainly refer to past arbitral awards. In the end, they rarely rely on the case law of other international courts and tribunals, like, for instance, the European Court of Human Rights. So let's focus on past arbitral awards. The reason why they rely on those past arbitral awards, they use them as a subsidiary source to shed light on the meaning, the content of IA's provisions. So we've just mentioned the fair and equitable treatment, for instance. So more precisely, tribunals rely on one or a few precedents, or they rely on jurisprudence constante, which are supposed to be made by a series of arbitral awards. So, irrespective of whether one speaks of single awards, few awards, or series of awards, there is the issue of similarity. Are those past awards tribunals rely on similar or sufficiently similar to the case at hand before them? In particular, are the international investment agreements which were applied in those past cases, are they sufficiently similar to the IAA that arbitral tribunals are called upon to apply in the settlement of the dispute? This is an important issue in methodological terms, but more fundamentally, this is an issue in as much as this may lead to situations where the interpretation which derives from relying on past arbitral awards we can lead in a situation where this interpretation conflicts with the intent of the state parties to the IAA, which is interpreted by the tribunal. So I think that similarity, not only an issue in terms of methodology, but an issue in terms of the intent of the state parties. Moving on to domestic laws, which are also relied on to interpret vague IA provisions. Here, if you look at arbitral practice, you can see quite easily that tribunals are quite selective when they refer to past to domestic laws. They only refer to a few domestic laws. And also, they usually hardly inquire into their similarity. So, is this a problem? Well, the lack of discussion of similarity is no doubt an issue. What about selectivity? Is it a problem? Well, I think this depends, actually, as was also argued by Pitt. When the intent is to fill gaps, the recourse to domestic laws is intended to evidence the existence of a general principles of law recognized by civilized nations. We know that those principles were incorporated in the statute of the PCAG to avoid non-liquid. Here, selectivity is an issue, a problem, because representativeness is a key component of this primary source. But when the intent is to confirm an interpretation which was reached on other grounds, this is less of a concern from a legal point of view. But is that true from the point of view of legitimacy? Actually, no. I think then from a legitimacy point of view, this is also an issue. I will explain this moving on now to the discussion of the legitimacy perspective. So here I will discuss this perspective in relation to argumentation. And I will focus on domestic laws and also on systems and paradigms, those which are relying in investor-state arbitration. But maybe first, why am I all of a sudden talking about argumentation? Well, here I'm talking about argumentation because, in a nutshell, when the law is vague, its application requires choices to be made between several interpretations. Because a choice is to be made, a justification is to be provided. Arguments need to be given in order for courts and tribunals to convince, or at least to try to convince their audience. So this is where the selectivity of arbitral tribunals as regards domestic law is an issue. Because a pick-and-choose approach opens up a Pandora box of criticism about notably legal cultural biases, which have the potential to undermine not only the acceptability of the award, but more fundamentally the acceptability of the system as a whole. The problem in investor-state arbitration is obviously that the audience is very, very diverse. You have a distinction that can be made between the disputing parties and a broader audience. You can make a distinction between states and investors as forming two different groups. You can make a distinction between states and civil society, states not being considered at least sufficiently as representing the public interest. This diversity, which has consequences in terms of expectations, is to be linked to the various paradigms which are relied upon by tribunals. None of those paradigms can individually, in itself, provide a justification to awards and to the system which is acceptable by all these audiences. As a result, as long as the regime will be characterized by an hybridity and by a vague identity, actually this will be impossible for tribunals to convince everyone. There will be criticism from one side or from the other side. So this sounds pretty negative. But I think I can fairly conclude on a positive note in this regard. Of course, in investor-state arbitration, like in life in general, it's impossible, almost impossible, to convince everyone that one made the right choice. That being said, I think that life also teaches us that it is easier to convince people in systems which, from a procedural point of view, enable people to be informed and to express their views, and in systems which, from a substantive point of view, display common paradigms. And I think here we have an evolution in the past year in investor-state arbitration and in international investment law more generally. Indeed, be it in lawmaking or in dispute settlement, there have been various mechanisms and fora which have been set up which precisely enable this diverse audience to participate, to express their views. And I think that at some point this will help the system in making progress to find its own identity, a process which will in particular lead to limit, I think, the need for systemic comparative reasoning, and also maybe this will make it easier, or in any case less difficult, for tribunals to convince their audiences. I will stop here, and I look forward to discussing this with you. Thank you.